Good afternoon and welcome to Introduction to Intellectual Property. I'm Lauren Pafumi with the FLC Management Support Office, and I'll be facilitating today's webinar. In this webinar, we will cover a comparison of real, personal, and intellectual property, or IP, the basics of IP and IP laws, types of IP, a review of Supreme Court cases concerning IP practices and policies, and protection and patents for IP. The presentation will run about 45 minutes, followed by a Q&A period of about 15 minutes. Please type your questions into the chat box marked Questions in your webinar menu, which should be on the right-hand side of your screen. You may submit questions at any time during the webinar. If you have technical questions or issues, you can let us know using the same method. Slides and a recording of this webinar will be posted online within a week. You will receive an email with information about how to access the recording. At the end of the webinar, a survey will appear. Please take the opportunity to let us know how we did. Our panelists today are Mariam Azarian and Marianne Lynch. Mariam Azarian is an attorney at the Office of General Counsel at the Department of Veterans Affairs, where she handles technology transfer, research, intellectual property, VA nonprofit corporation, and health law issues. She has experience in technology transfer at 3 different agencies and also as an inventor. Today we'll call her MA. Marianne Lynch is a general attorney at the Office of General Counsel in the Department of Commerce. She provides legal guidance on a wide variety of issues, including intellectual property. She has more than 20 years of experience in technology transfer and as an IP attorney at 3 different agencies and a support contractor. Today we'll refer to her as ML. Thank you both for joining us today. Now I'll turn the floor over to MA and ML.
Hi, this is Mariam Azarian. Good afternoon or good morning, depending on the time zone you're currently located. As Lauren mentioned, today we're going to talk about intellectual property. And I like to emphasize that today's training is really a beginner's overview. And given the timeline, we're only scratching the surface when it comes to intellectual property. Since this webinar today is hosted by the Federal Laboratory Consortium, FLC, there's obviously a bit of federal angle to this. So bear that in mind. We have a number of folks that are joining us from university and the private sector, but a majority of folks on the webinar today are federal employees. We're going to go ahead and first begin with the concept of property. When we discuss the concept of property, we break it down to 2 main types, tangible and intangible. Under tangible property, we also have 2 main types, real and personal property. Now, real property is associated with your home, your land, and your home or land, whether it's a townhome, a ranch, or a McMansion, has a deed, and the deed identifies the metes and bounds of that property. Now, real property can't be moved. It's there, and it's affixed. The second category under tangible property is personal property. Now, personal property can be moved. For instance, think of your car, your cell phone, clothing, or your computer for that fact. You can move it around. Now, going back to the concept of property, the second type is intangible property. It's the property that technically can't be touched or held. It includes any item of work that's not necessarily physical in nature, property of the intellect. Examples ultimately include, for instance, copyrights, trademarks, or goodwill. Now, we're going to talk about copyrights in a number of slides. A copyright doesn't necessarily derive value from the paper it's recorded on, but the property still has value. And the law, as we're going to see, recognizes and protects that. Now, similar to your house, where you don't permit anybody just to enter the place and trespass, you can permit somebody to actually come on your property, or you may lend your computer or your cell phone to a friend. You can do similar things with intellectual property. Intellectual property can be owned, sold, assigned, licensed, willed, and the rights can transfer, just like you can sell your house or, like I said, lend your laptop to a friend. So the same rights also are applicable to intellectual property. Today we're going to talk about the four main types of IP: patents, copyrights, trademarks, and trade secrets. Now, for patents, obviously we're going to go into depth a little bit more, but just think about all the various technologies that goes into your smartphone or your cell phone for that matter. Think about the touch screen and how the capabilities actually function. All of those particular technologies most likely are protected by various patents. For copyrights, think of the movie, the novel, the latest rap song, the latest episode of Breaking Bad, for instance. All of that type of property is protected by a copyright. Now, for trademarks, just look around. Whether you're looking right now at your monitor may have a Dell logo or a Samsung logo or the Starbucks coffee mug that's sitting in front of you. All of those are examples of trademarks. Now, for trade secrets, everybody's heard of the Coca-Cola formula, but in addition to Coke, there are numerous types of trade secrets in industry. Think of the formula of WD-40, the recipe for Thomas's English muffin. Another good example is Google's algorithm. Now, the algorithm is a trade secret of Google, and it mixes information from a website's relevance, the number of visits, the links, the anchor tags, whatever, user location, a number of variables, ultimately be able to provide the best research results for each of the users. Now, intellectual property jurisdiction, and we've identified it here on the slide, it goes way back to the Constitution. Article 1, Section 8, Clause 8 of the U.S. Constitution authorizes Congress to enact patents and copyright laws. The Commerce Clause, Article 1, Section 8, Clause 3, is the basis for Congress to regulate trademarks. And states retain concurrent jurisdiction to regulate intellectual property under the 10th Amendment. Now, intellectual property is really about a balancing act, and part of the balancing act truly is to create a competitive marketplace. In our legal system, we're providing certain rights and protections for owners of property, and these are types of property rights that result in the fruits of their mental labor. And we want to encourage this creation. So we're giving, under law, the creators, the authors, the inventors, certain property rights for their creation. Now, be it a book, be it a movie, be it a widget, or be it the new microchip. And the premise of this is to create a competitive marketplace. Now, all these laws ultimately come back to our founding fathers. And our founding fathers were great innovators and inventors. For instance, many of you, if you read the history of Benjamin Franklin, you may know that Franklin actually had poor vision and needed glasses to read. He got tired of constantly taking them off and on, so he decided to a way to ultimately make his glasses see both near and far. And he had two pairs, and he cut them in half and put each half of the lens in a single frame. Fast forward today, and those are called bifocals. So they were inventors and innovators, and they saw the value of intellectual property. So some of the laws you see today are as a result of our founding fathers truly being innovators and inventors themselves. So public policy is a balancing act. We promote creation by giving property rights to the creators for their creativity. We provide public access in order to promote a competitive marketplace. Think of the various smartphones we have. Provide creators, owners rights to exclude or control use of their intellectual property, which is a government-granted monopoly. So with that, we're going to segue into the first area that we're going to talk today, and that's going to be patents.
Hi, this is Marianne Lynch, also known as ML for this presentation. I'm going to talk briefly about patents. Patents are the intellectual property that people often think about if they're going to think about intellectual property. A patent is a temporary grant from the U.S. government that allows the owner to exclude others from practicing the invention. Now, what practicing the invention means is to make, use, offer to sell, or sell the invention that's claimed in the patent document. Counterintuitive, the patent does not grant the patent owner to actually practice the invention, although that's the idea behind applying for a patent. There are some government restrictions on potentially practicing, but typically that is the expectation, and that's normally what happens. It's just not a guaranteed right. It's the guaranteed right to exclude. Patents are filed by country, and they're granted by countries, although later I'll mention that there are international patent applications, and they can be filed first, but they have to be filed up by or followed up by filing in individual countries. So there are three basic types of patents. There's a utility patent, design patent, and plant patent. Now, typically when we talk about patents, we're really talking about utility patents. They're the most common, they're the most familiar. A lot of people even forget there are such things as design patents and plant patents. And they have a use and they have an application, but we're not going to focus on that in this conversation, this presentation. Mostly I'll be talking about utility patents. And when you think about government and private funding for research, typically a patent that would result from that would be a utility patent for inventions under that funding. So that said, go on to the next slide. What is patentable? Now this goes, to be an invention, it has to be a conception. It has to be a creative step, and it also has to be reduced to practice. Reduced to practice is essentially showing that it works. It can be shown that it works with a model. It could be shown with data. You don't have to have a three-dimensional model, but if you have it, that's great, and you can actually submit that to the United States Patent Trademark Office when filing the patent, or prosecuting the patent. But they're also the subject matter for the invention. So the things that are patentable fall into these categories. They have to be a process, machine, manufacture, composition of matter, or new and useful improvement of any of those above. So all inventions and patentable inventions fall into those categories. So in addition, besides being an invention that's been reduced to practice and falling into that subject matter, they also have to be useful, which is a relatively small hurdle, not useful necessarily in a normal word, but it has to have some purpose. It has to do something or have some purpose, even if it's just for amusement. So no matter how limited. Then novel is it has to be new. Nobody else has to have done something else exactly the same. Now, non-obvious is a little tougher because it's not just exactly the same. You also have to make it so that if this is a combination of a couple of other things, that someone, the theoretical person who's ordinarily skilled in the art, would they have anticipated putting together these elements to make an invention? If it's what they call obvious or anticipated, then that can make the invention unpatentable. So that's the criteria. Those are simple criteria. There are others, but those are the three things that people right off think about what is patentable and what is not. And prior art, which I will talk about shortly, is what we look at to determine whether something is novel or non-obvious. Now, prior art is the information that was available to the public in any form before the effective filing date. Now, if you look at the prior art and you can see that this invention was already out there in the public domain, it was being used, then it's no longer novel. It may have been novel 10 years ago, but it's not novel at the effective filing date. And so prior art is any information in any form that can be found, and it can be in a foreign country, it could be buried in stacks of paper somewhere that almost nobody could find, but if it exists, and if it can be found, it can be prior art. It's before the effective filing date, and it's relevant to the patent claims from, again, that person who's ordinarily skilled in the art. Now, one of the things that's very important about prior art is if it's known to the inventor or to the attorneys working on the invention, anybody who's associated with the patent application, and it's relevant, it has to be disclosed to the USPTO during the patent prosecution. If those parties know about relevant prior art and they don't disclose it, it could be considered inequitable conduct and potentially invalidate the patent. So this is a negative in a way, because the way the statute reads is an invention may be patentable unless, and this has to do with the novelty requirement. And I won't go into too much about patent prosecution because this is a beginner intellectual property, but this is just, some of the criteria for determining whether something's novel, and again, concerns prior art. It's unless it's claimed in an invention in a printed publication. So, and basically in use, on sale, otherwise available, again, effective filing date. And the other is in a published patent application. And so if somebody else has patented it, even if the patent hasn't issued, that's still, or filed for a patent, that's still considered prior art. Now, the exceptions for these disclosures protect somewhat the inventors of this particular patent being filed. So they have a 1-year grace period for their prior art not being used against them. Now, there's a lot of details to this, and in general, they should just keep their mouths shut before they file the patent, because there's a lot of details to whether it's prior art or not, even if it's their own. And I cite the regulations, so anybody getting involved in this would be, well advised to be very careful about establishing potentially their own prior art against themselves. So priority of invention. This is changing law in the United States. I guess almost 2 years ago, the America Invents Act was signed on September 16, 2011. 18 months after that, in March 16, 2013, so just a few months ago, the United States switched from first to invent to first to file. And so the patent application process has changed, because in the past, you could submit something even if somebody filed first. Potentially, you could get the patent if you could show that you were first to invent. It was sometimes a very complicated, onerous process, but if you could document and prove that you were first to invent, that party could very often get the patent instead of the party who came to the PTO first. That's changed now, effective March 16th. So that is more consistent with the rest of the world. And this, the patent industry is getting used to that, and again, all the people associated with that. So what is patentable subject matter? I talked a little bit earlier about what patentable subject matter was in the general categories about processes, manufacture, and whatnot. And here are some examples. Proper genetically modified seeds, genetically modified mice like the Onco mouse. Business methods are also patentable. That's a process. Amazon one-click, a lot of people have criticized that being granted a patent, but it is. Compositions, drugs, things like that, articles of manufacture. Now, we specifically mentioned this particular article of manufacture, complementary DNA, also known as cDNA, because it's brought up in a Supreme Court decision I'll talk about later, the Myriad decision, which is a very recent Supreme Court decision. So that's considered not a product of nature because there's enough creation, inventorship steps to obtain this cDNA. Now, improper, immoral, mathematical formulas are almost like a law of nature. Naked ideas, product of nature, isolated DNA. And in the Myriad decision, the court distinguished between isolated and complementary because isolated DNA was considered an extract that was just removed from a cell, as in a product of nature. And whereas the cDNA, there was more manipulation, so that was considered an invention. So that's where the court drew the line. And these are just some terms to be familiar with if you're involved in patents. Provisional patent is a quick, inexpensive way to obtain a filing date and to put your marker down for an invention. It's not reviewed by the USPTO. There's no patent granted under the application, the provisional application. It's only good for 1 year. If it's not followed up by a regular patent application, you lose it. You don't get the filing day. You don't get any of the advantages of filing the provisional application. The regular patent application can be filed independently. It doesn't have to have a provisional application before it, but it can. It has to be filed within the 1 year provisional application time frame if it follows up a provisional and to get the filing date. This is what's reviewed by the USPTO. This is where all of the disclosures are required for prior art and everything, and the claims have to be included. It's a complete patent application, and that's what a patent is granted under, the regular patent application. The PCT is also known, Patent Cooperation Treaty, as an international application. And so in some ways it's comparable to a provisional patent application because there are no patents granted as a PCT. You have to file a national stage application, and that's where you deal with the individual countries under the PCT, and that's how a patent is granted under that system. And with that, I'll turn it over to Miriam for copyrights.
Thank you. So the second, actually the third, it is the second type of IP we're going to talk about will be copyrights. Now, copyrights, they're also a statutory property right, which they're granting to creators, and under copyright law they're called authors, certain exclusive rights to their creation. And if you remember from a couple of slides ago, we talked about the reference in the Constitution, and ultimately it's to promote the progress of science and the arts, and ultimately by providing certain economic incentives for creative activities. Now, copyright protects the intangible original work of authors, which can be fixed in a tangible medium of expression. Now, ultimately what that means is that copyright protects the expression of the idea, but not the idea itself. Now, here, as the slide demonstrates, there's certain types of protection. It's for original works of authorship, including literary, dramatic, musical, artistic, and certain other intellectual property works, both published and unpublished. Now, registration of a copyright with the Copyright Offices in Washington, D.C. is not required for an existence of a copyright. However, it's definitely a prereq for a lawsuit for copyright infringement and if you would want to be entitled to certain legal remedies. Now, copyright is often described as a bundle of rights. Now, what are these rights? The rights ultimately are to reproduce copyrighted work, to prepare derivative works, to distribute copies or phonorecords, to perform copyrighted work publicly, or to display copyrighted work publicly as well. So these are all the bundle of rights that would be entitled to the copyright owner. Just waiting for the slide to load. Copyright subject matter under 17 U.S.C. 102A. We've identified them here: audiovisual work, musical work, anything from various songs or music to software for instance, the GoToWebinar software that made the live meeting today available, that is protected by copyright protection. In addition to that, literary works, architectural works, motion pictures, all your movies, sound recordings, all of them, whether it's your book, your movie, your painting, number of ways that you are able to get copyright protection. Copyright has two main requirements. One, it requires authorship. It's not defined under the Act, but it includes individuals and legal entities. And the second prong, it has to be fixed in any tangible medium of expression. So it has to be sufficiently permanent or stable to permit it to be perceived for more than transitory duration, directly or with an aid of a machine or device. So think about you today. If you're sitting in front of the seminar today and you're taking notes with a pen on paper, you're using your pen, it's an aid of a device, and you're taking notes on a sheet of paper. You are the author, and using the pen, you're putting this in a tangible medium expression, those notes. Or if you're using a computer, using a Word program, and typing in with a keyboard into a program, you're using the keyboard as the device and typing it into the Word program. You, the author, once again, putting in a fixed, tangible medium of expression. Copyright duration. Now, I want you to take just a small history lesson going back in the late 90s, and many of you may have heard of the Mickey Mouse Protection Act. So back then, Disney had a number of copyrights which were about to expire, and they lobbied very, very strong to get copyright extension for a number of Mickey Mouse, ultimately, movies that are about to enter the public domain. So what you see on this slide is as a result of Disney ultimately lobbying heavily and getting extension for copyright, and this is currently the law. The copyright duration, currently under the Copyright Term Extension Act, also known as the Sonny Bono Copyright Term Extension Act of 1998, ultimately extended copyrights, and one, for the individual author, it's the life of the author plus 70 years. For joint work, life of last to die author plus 70 years. Now, for made-for-hire works, it's the shorter of 95 years from the first publication or 120 years from creation. And this was actually very contentious at the time because obviously Disney had a number of copyrights that were about to expire, and they were lobbying hard to get extension for that. As you remember, we talked about protection should be for a limited time, and now they were asking for an extension. Now, copyrights and federal agencies. Copyright protection is not available for any work of U.S. government employees as part of their official duties. Now, the U.S. government, however, can receive and hold copyrights transferred to it. There are only two agencies that I'm familiar that are able to get limited copyright protection. As a general rule, copyright protection is not available. One is the National Institute of Standards and Technology under Department of Commerce has very limited copyright protection, and the second is the U.S. Postal Service. No other federal agency provides those types of copyright protections for their employees. Now, having said that, we can't file in the United States for copyright protection. However, works of U.S. government employees may be able to get protection overseas. For instance, we have some copyrights that are filed in the UK, and we have protection for them overseas, but not in the United States. So with that, we're going to segue into the third area, trade secrets.
This is ML again. Talking about trade secrets. Trade secrets are a different kind of intellectual property because it doesn't have the same relationship with the other kinds where part of the value is from reporting to the government, registering or filing with the government, and then using the protections that the government grants that way. Trade secret is information that has economic value because, partly because anyway, it's not known and is subject to reasonable efforts to keep secret. So it's it's a business decision whether to keep trade secrets, and there is no filing of trade secrets. It's the idea is you're keeping it under wraps and protecting it. So the trade secret advantages, they cover a lot of things. Basically, any information that has value that can be kept secret. It may or may not qualify as patentable, and it may or may not be copyrighted if it were some kind of written document or whatnot. Not only does it not require disclosure, the disclosure has to be controlled. There is no requirement for disclosure to the government, and any disclosure otherwise is, should be protected. The duration for trade secrets is potentially forever. It's indefinite as long as the secret is kept, and as long as it has value, the party is likely going to try to keep it. So just waiting on the slides here. It doesn't, I don't know if anybody else can see what the slide says, but okay, trade secrets. Okay, it can be business information, software, algorithms, databases, processes, ideas. The idea is it can overlap with patentable subject matter. So, because that's a similar list, as I mentioned before, for what is patentable subject matter. And so, again, it's a business decision on whether something be kept as a trade secret, with the idea, how hard would it be to patent? Is it patentable? And what would be the value if I kept it proprietary and private versus what, so the parties typically weigh the pros and cons and decide which way to go on trade secrets versus patents, if it is patentable. So the idea how to protect the trade secrets, and something can be held as not even a trade secret if there was some kind of violation, if they didn't take precautions to keep the access limited. So the access has to be limited. The individuals, they sign non-disclosure agreements, especially if any of it's being disclosed to outside parties, but even internal to the organization, it should be stamped confidential. It should be kept in locked offices, potentially a vault, depending on the importance, and it shouldn't be disclosed to more even internal employees than necessary. It should be kept as quiet as possible and as practical. So the way trade secrets with the government doesn't keep their own trade secrets. They don't say, oh, this is a government trade secret. The government does keep confidential information, but that's a slightly different concept. Typically, trade secrets are considered proprietary information, so a lot of overlap in what's covered and how it's protected, but proprietary tends to be more business-oriented. The government, though, has access to trade secrets as part of their regulatory activities and other kind of activities where businesses have to disclose their proprietary information to the government. And so not to disadvantage the businesses too much, there are protections with how the government uses this information and doesn't use the information. So there are some criminal statutes, federal criminal statutes, state statutes, the Uniform Trade Secrets Act, which many states have signed up to, or something very close to it, that protects information when it's disclosed to the government, so that the businesses have confidence that they're not compromising their own business model or their secrets by disclosing to the government. And to cite a couple of them, there's the Economic Espionage Act, and it can be considered a federal crime with potential jail time and financial penalties if somebody has violated this. So the government takes trade secrets very seriously. It's just that they don't hold their own. So that's it for the trade secret discussion.
We're going to go ahead and talk about the last area of intellectual property now, trademarks. Now, I think trademarks are probably the funnest area of IP. Now, let's go back to our slides here. I think we're all over. Let me try to.
I think I got you back on track, Miriam.
Okay, thank you. One earlier. Go to the one. Thank you. Great. So as I was saying, trademarks are probably the coolest area of intellectual property. And when we think about trademarks, think of all the brand names. And trademarks ultimately, they're associated and trademarks and service marks are associated with a source or standard of quality of a product or a specific service that, we as consumers purchase. Now, trademarks and service marks, they can be words, phrases, designs, sounds, symbols, and ultimately the public learns through this purchasing experience that the goods and service are synonymous with a certain expectation. So you know that the next time you're going to buy Yankee candles, it's in a particular jar and it has a particular scent. It's ultimately the predictability of the quality and the assurance that you get that is very important, that you get that consistently, and companies stand behind that. So as the slide indicates, it's a word, term, symbol, device, color, sound, or a combination of these. Trademarks, unlike patents that for a limited duration, they can be renewed forever so long as they're being used consistently in commerce. Now, a few examples. McDonald's double arch, MSN's butterfly, the shape of the Coca-Cola bottle, but also note chimes. For instance, the note chime for NBC, which is a sound bite trademark for NBC, da, 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 and that's a registered trademark of NBC. Now, in the federal government, we also have trademarks. If you look at the slide here, we've just got a sample of various trademarks, whether you're a big hockey fan or big Apple or Target fan, you see, you know a product exactly. When you look at Apple, there's a product behind that. Now, to the right of it, there are two trademarks. One is a registered trademark of the United States Army for DOD, and the one to the right is actually a registered trademark for Department of Veterans Affairs. A blue button, download my data, which is associated with downloading health information, identifiable health information for veterans. Interestingly, this particular trademark was subsequently assigned to Health and Human Services. So within agencies, we actually do assign we file trademarks, we get protection, and we also assign our trademarks. Now, trademark rights ultimately arise in one of two ways. You either by filing a mark with the United States Patent and Trademark Office based upon a bona fide intent to make use of the mark on a product or in association with a particular service that's going to be soon offered to the public, or by actually using the mark in commerce or in a product. Federal trademark registration is valid for 10 years, and it can, like I said, it could be renewed for periods provided it's going to be constantly used. And failure to use the mark can cause the rights in the mark to be lost. Finally, there are special types of marks which we're not going to get into, called various ones, collective marks or membership marks, which identify organizations, and there are members and certification marks which are used to identify the fact that a product or service meets certain acceptable standards. So think of the Good Housekeeping seal or Product of Idaho. Those things, once again, are a type of trademark. In any case, this slide here just pretty much summarizes the type of requirements and where you file, the registration, use, and intent, and the federal law that provides for protection of under the Trademark Act of 1946. So we just gave you a very, very quick overview of intellectual property. Like I said, we just talked in general about IP, and we can, going into each area requires more in-depth discussion. But we also wanted to talk about, from that segue on, and talk about what IP was, to transition and talk about a few important things that are important to be aware of regarding intellectual property. One is, what does it mean when IP is in the public domain? That copyright's in the public domain, the patent's in the public domain, the trade secret's in the public domain, whatever that IP is. So works in the public domain are those in which the intellectual property rights do not exist, have expired, forfeited, or just inapplicable. So let's say for whatever reason, the secrets of Coke are out. We all know what formula, A, B, and C. Therefore, that trade secret just does not exist anymore, and it's available in the public domain. One can use IP, for the most part, that's in the public domain without infringing. Remember, infringing is identical, synonymous to trespassing with your own property. Okay, let's going on to the next slide. Let's try this again. I think we have a little bit of a malfunction. It's not going to.
So Miriam, you should be on IP infringement, is that right?
No, it's not moving.
Okay, we have it moving here, so if people can see
great. Thank
IP
you.
infringement, they can raise their hands if they want, just to make sure.
Thank you. I now
Yep,
see
they
IP
can see it.
infringement. I think slide 37 on the monitor. Thank you.
It looks like people can see it. Thank you.
Great. So IP infringement, as we discussed trespass earlier, it's pretty much synonymous to trespass on tangible property. You're violating the intellectual property rights, IP owner's exclusive rights. And infringement can involve using, selling, reproducing, distributing, displaying, or performing without the author or the owner, or ultimately without the permission. Oh, I think we're there. I think we skipped a slide, but that's okay.
Yeah, we did. We skipped a public domain slide, but
I think, well, that's okay. This is the slide we skipped, and let's go back to the slide. So we talked about what is it in the earlier slide right before. We talked about IP in the public domain, and the corollary to that is, what is the goal? Like, how is that going to? Why is that important? Because the goal of the IP owner is generally to keep IP out of the public domain and to retain exclusive rights as long as they can. Think of Mickey Mouse. Think of Disney. They wanted to keep that copyright out of the public domain, so they could still benefit from that. And sometimes there's a bit of a tad of friction. I want you to go back to during the Clinton administration. When the Human Genome Project was there were sequenced in the Human Genome Project, the government's interest was for that to go in the public domain. And that was not necessarily the interest of biotech at that time. So sometimes the interest of public versus private can be in a bit of a conflict. And with that, let's see if the slides today work, and they are working. We're going to now talk about a number of hot Supreme Court cases. This is obviously not an exhaustive list, but Marianne's going to go ahead and give us an overview.
Okay, this is ML again, and I will go over these pretty quickly because I want to leave some time for questions. So there are a few cases here. The first was decided only a couple months ago, Association of Molecular Pathology and Myriad Genetics. And this was basically a case about patentable subject matter. As I talked about subject matter, patentable subject matter earlier, products in nature are not patentable. And so the court decided that this particular invention from Myriad Genetics was a product of nature. It was isolated DNA. And the court held that there was not enough of an inventorship step there for it to be considered anything but a product of nature. But they did contrast that with complementary cDNA, which is more manipulated and they say created in a laboratory. And so they drew the line between that. One wasn't enough distinguishing from product of nature, and the other was enough of inventorship to be considered that. So this is basically a subject matter biotechnology case. The next one is more, it's not so much patentable. The Bowman versus Monsanto genetically modified seeds, so they were patentable. Nobody questioned the patent, but it was how it was being used. So they Monsanto licensed the seeds to farmers, and they had a restriction on that license that they couldn't be replanted. It was a one-use thing, and that goes to the exhaustion doctrine, is when you purchase something that's patentable, you get to use it unrestricted. But this was a license, so it wasn't an unrestricted use. It was a restricted use. So the court held that the exhaustion doctrine didn't apply here, and that for somebody to be able to replant the seeds would not be applicable for this particular thing, because it was really more of a one-use application. So again, this isn't a subject matter. This is how the patent is used. So Monsanto won in this particular case, and as I mean, the court held is basically the fact that the patent technology can replicate itself does not give the purchaser the right to use replicated copies of the technology. So again, you can't, when you purchase an invention, you don't get to make it over and over again. You just get to own what you bought. So the next one is a biotech case also, Mayo versus Prometheus, and this is a patentable subject matter case also, and it goes back, it's a 1.5 years old, and it goes back to this correlation wasn't enough of an inventorship step. The court held that it wasn't patentable subject matter, it was more of a natural law. So, and you know, I'm sorry I can't have more time to go into the details, but I really do want to leave time. But the court held that a newly discovered law of nature in itself is unpatentable, and the application of that discovered law is typically unpatentable unless there's a little bit more than a simple correlation. And so Stanford v. Roche, this is not a patentable issue. There was a patent, actually a few patents issued. It was really who owns the patent. And so in this case, there was an inventor who assigned to two parties, Cetus, and then Roche acquired a Cetus, and Stanford. Stanford thought that they owned the patent outright, but this inventor had assigned to Cetus/Roche also. So the idea was hereby assigned was considered immediate, and agreed to sign, there was a lag. And also, the idea behind this ruling, or the reason why people care, for a couple reasons, is one is it's noteworthy, so that organizations, they should look at their assignments, hopefully they have already, and make sure that they're clear and they're closer to hereby than agree. And also the fact that Stanford brought up by Dole Act, saying they should win because they had to assign some rights to the government, and the court held, no, you better just make sure your assignments are good, because the inventions vest in the inventors first, and so Stanford couldn't rely on by Dole, sorry. And
Marianne, I know
this
that you
last
want to
one,
get to these,
okay.
but I definitely
Yeah,
we gotta get to the questions. We're running a little bit behind. We want to make sure these great questions get heard. So if you can sort of
wrap up. This one is just a trademark deletion, and you know, you can read up on it later about the little guy versus the big guy. The court held that there wasn't enough proof of dilution, and then these are the resources that we can look at, you know, and we specifically mentioned Federal Laboratory Consortium. And this here we have tables with basically a summary of most of the information we just covered. These, it goes for 2 pages, covers all the IP we just talked about. And with that, we can go to questions.
Okay, great. So that set of slides there will be posted, is already posted up where you went to register to the webinar, so you can have better access to that. So let's start with, it looks like our first question is for Mary Ann, MA. So how much does it cost to get protection for any of these forms of IP?
Okay, so in general, the patents are the most expensive. So for utility patent costs, beginning with attorney and whatnot, a simple patent, $10,000, and it goes quickly up from there depending on how complicated the patent is. $20,000 baseline for biotech. Copyrights are a bargain. They're $35 fee for electronic filing, and typically you don't need an attorney. Trademark costs, normally you would use an attorney, so $1,500 baseline for an attorney and about $300 for filing, so call it $1,800 baseline. And trade secrets, just the cost of keeping the information secret.
Okay, great. So next question looks like for MA. How is inventorship different from authorship?
That's a very good question. So first, in the context of things, where inventorship refers to patents, as we described, and authorship, I think, can describe 2 things. One is actually being an author on a publication, or authorship under copyright law. Being an inventor on a patent gives you undivided interest to the patent, and it doesn't matter the order of if you're first or if you're last. If the individual who asked the question is referring to now a manuscript, under standard scientific practice, it does make a difference who's the first author or who's the last author and who goes in between. Generally, the person who did most of the work is the first person, and there are different people in between as well. Now, regarding inventorship, if the wrong inventor is identified on the patent, it invalidates the patent. However, that's obviously not the case when we're talking about a manuscript. So when folks work that out scientifically, there's standard scientific practice on ultimately who's first and who ends up being last. And ultimately, inventorship and authorship, depending on which context this questionnaire is asking, depends on the contributions of the parties, who did what. Mary Ann, do you have anything else to add?
No, I think that was good. Thank you.
Okay, great. We have another question coming in. I think this one is for you, Mary Ann. Regarding patent slides, what are examples of naked ideas that are not patentable?
Well, I guess naked ideas as far as like E equals MC squared. I don't know if that's a naked idea, but it's a formula, just the perpetual motion machine. Things, an idea with really reduction of practice, I guess. You can have a lot of clever ideas, but if you can't execute them, if you can't show that there's anything more there, then it's not patentable.
Okay, this one's come in a couple of times now, so I want to get this one to Mariam, MA. When the government researchers do work, it's not subject to copyright protection, but what happens if they collaborate with other colleagues? What happens when you mix a manuscript?
Oh, that's an excellent question. So in that type of work, when you have government work and non-government work, that becomes ultimately joint work, and it's ultimately, depending on, it could be merged into one work product. The question you need to ask, as we all know, U.S. Government employees' work is not subject to copyright protection. So you need to be able to see to what extent you can isolate the contributions of the government employee from the contributions of the non-government employee. Now, if on the other hand, as the individual asked this question says, that you're collaborating and it results in this joint work that, it could be inseparable. The data, the tables, it's science. We share data. It may be ultimately impossible to determine whose contributions are who. Therefore, it could be an inseparable joint work and impossible to isolate. So the law is a bit unsettled in this area, and if you get a circumstance like that where it's inseparable, I would suggest you contact your general counsel's office for additional guidance.
Okay, great. Next question looks like for ML. Our scientists are encouraged to present their research findings at conferences or to publish articles. How does this impact the government's ability to then patent a unique or innovative technique or technology?
Well, hopefully it wouldn't impact it, because if they know ahead of time, which they should, if they're going to be presenting work, they should look through everything they're thinking about presenting and see if there's anything that they need to protect. And they could, work with their tech transfer office for maybe to discuss what patentable inventions are in there and whatnot, and have them file a provisional patent application, if nothing else. This is a common situation, but before any kind of public disclosure, they should be assessing what's in there. And considering also not disclosing it at all if it's not quite ready to file a patent, but it's potentially patentable down the road, to keep the disclosure more vague or not to include it.
Okay, great. Another question for you, ML. To whom do you disclose?
Very often you would work with your management to see, and your coworkers to see if there's anything patentable in there. Maybe do a rough prior art search, or, if you're familiar with what other, inventors are doing or other researchers. But then you'd typically work with the tech transfer office. And normally there are standard forms for reporting an invention report or something like that, and then they can do also a prior art or work with other parties to see whether the government wants to patent, because a lot of things are potentially patentable, but the government doesn't patent.
Okay, we have time for a couple more. Let's see, one from Mariam. Where are trademarks registered?
The United States Patent and Trademark Office. So then not only do the USPTO handles patents, but also trademarks, and just like patent examiners, they're trademark examiners, and they would take you through the whole process. You file, as Marianne explained, there's certain costs that you have to file as a result of your trademark, and you submit it, goes through an examination process. Not as lengthy as patents, but hopefully if it merits a trademark, then you get an issued trademark.
Okay, great. Now I think we might have time for one or two more. This one might be a long one, and I think it would be a good one to end on, so it's for both of you. And someone has asked, what aspect of intellectual property interested you to pursue a career in this field?
Marianne, do you want to go first?
Yeah, I'll go first. Actually, I guess, I went to law school while I was working as a scientist, basically. So patents were of particular concern because I like the idea of the technology and the inventions and whatnot. So that's what drew me in. The other parts are for me, periphery, but patents are what, and the technology that's involved are what I find most interesting.
Likewise for me, this is Miriam. I was a scientist in I guess, former life. I really very much enjoyed science and made the segue. Ended up having actually an invention, was at this time, I think it was licensed, or waiting still for the royalty income to make me afford a BMW in my driveway, and that hasn't happened yet. And then made the segue into law school. And IP has been, actually, it's a very fun area of law.
Okay, great. Well, looks like that's going to be about all the time we do have for today. But what we are going to do is we're going to save all your questions, and if we haven't gotten to you, we'll respond to you offline. So your questions will be answered hopefully pretty soon. So thanks so much, everyone, for submitting all the questions, and that concludes the Introduction to IP webinar. And on behalf of the Education and Training Committee, thank you both, Mariam and Mary Ann, and thank you as well to everyone who joined us today. We hope this webinar has proven successful. We hope this webinar has proven successful in introducing you to the basic concepts of IP. When the webinar ends, please take a moment to give us your feedback in the short survey that will appear. We'll keep you posted about future webinars, and we hope to see you back.
Thank you very much, Lauren.
Thank you.